Now, the general trend across the country is to recognize at the very least work product, if not attorney-client privilege protection for communications exchanged between the litigation finance company, claimant, and the lawyer. I'm going to give you a couple of examples here. In Arizona, the court in 2020, district court, ruled that the litigation finance agreement satisfied the because of test and constitute work product. And work product protection is not waived merely because work product is shared with another person or entity, right? The idea being that this is information that is created and exchanged in the pursuit of the case. In the Northern District of Illinois, the court just summarily said in 2014 that yes, work product protections apply to communications with funders, not attorney-client privilege. Makes sense. The Eastern District of Pennsylvania has held that communication with funders and funding agreement drafts were protected as work product and protected by the attorney-client privilege under the common interest exception. And that exception is a good one to think of. In the Eastern District of Texas, the court in 2011 concluded that documents shared with potential funders were privileged, period. Usually the analysis will focus on whether the client and the third party to whom the privileged information had been disclosed were engaged in a common enterprise. And that's why that comes up and is pretty helpful. And similarly, Florida in 2016, the bankruptcy court by statute looked at the statute in Florida, said Florida statute section 19.502C2 protects communications with those to whom disclosure is in the furtherance of rendition of legal services to the client. And that is actually very consistent with the model rule we looked at that has implied authorized disclosure. No protection in Delaware. The court decided that the companies did not have a common interest and therefore attorney-client privilege and work product protection were unavailable. New York, surprising, said that the identity. Now, so it's a limited scope ruling, right? That the identity of a person providing litigation finance, whether private, individual, corporation, is not protected. But that doesn't mean that all of the information exchanged thereby becomes available. Defendants have for sure been very eager to get their hands on litigation finance documents, usually to muddy the waters, and you know you're gonna sense the fact that I'm a plaintiff's attorney at heart. But it just creates a lot of noise and a lot of expense and a lot of side chains of discovery for no real huge reason. But there are certain states that require disclosure of at least the identity of the finance company. And that is because they have a vested interest in the outcome of the case. And you have to have that disclosure, usually in federal court, but in some state courts. So the disclosure is required. And these are the states: Illinois, New Jersey, Wisconsin, West Virginia, and Delaware, newcomer. And then the Northern District of California in 2016 held that disclosure was mandatory in cases involving class actions. Because in this case, the Northern District of California compelled the named plaintiff to produce their litigation finance agreement to the defendant. And therefore, and this was a case where there's a plaintiff's class action for damages resulting from the explosion of a gas flow. So this was actually then codified in the Northern District of California local rules. And those are now the rule, and there is a mandatory disclosure for class action cases.